the ADA and disability rights. I don't have a printed info because our presenter is a stand-in, but it's also, she's somebody that I think a lot of you already know. I don't have her resume because, again, they didn't give me a printout. But I can tell you she's an attorney, and she's a dear friend. I love her and her family like they're my family.
Is she personal injury?
And I'll let her. I'll let her introduce herself and kind of give you a background. But it's my sincere pleasure. Alisa Moen.
Thank you, Corey. And we are family, so he can say a lot of things that a lot of other people can't. I am an attorney. I am a stand-in. Unfortunately, Ms. Tomasi, who was supposed to do the presentation, got COVID, which, you know, this has been like the ongoing debacle. I'm not an employment law attorney. I occasionally practice in the employment area and usually call up a friend who does it for a living and say, okay, now it's a good handoff. But I've done it for over 20 years, so I kind of know enough to be dangerous and know enough to guide folks. And when I do get phone calls from friends or my Choroideremia family, I'm always happy to be a resource. So you can always call on me anytime. So without further ado, rights under the ADA. And I'll tell you, this comes up a lot. Having glanced at this presentation again, I did not prepare it. I'm just going to kind of walk you through this. A lot of it centers on employment rights and employment issues, but ADA is much, much broader than just employment, and particularly in a community where the disease impacts younger folks. Education is very much impacted by ADA rules and laws, and in fact provides a lot more protections to students because education is actually your civil right, whereas employment, you don't really have a right to be employed. It's not, you have a right not to be discriminated against based on your disability, but we all have heard the term at-will employment. So there's a lot fewer protections in the employment setting. Just kind of in the back of your mind, understand that ADA will give you other rights and other aspects of your day-to-day. This is Ms. Tomasi. That's not me, but she is the director of ABIDE, Accessibility, Belonging, Inclusion, Diversity, and Equity. I actually, when I realized I have to do this, I looked her up. She's phenomenal. She's got ridiculous pedigree, and she is truly a passionate advocate of community like ours. So the history of laws that protect individuals with disabilities, it's like an acronym soup, right? Whenever you deal with federal government or state government, it's very verbose, and typically we lawyers that marinate in those juices, we just refer to something as Section 504, and then we know what 504 is. And those of us who are parents and have school-age kids, we know 504 or IEP are those two different kind of pathways of providing accommodations for our learners. There's Individuals with Disabilities Act, 1975. It was kind of on the tail end of the civil rights movement. Certainly folks with all sorts of differences have rights and have a right not to be discriminated against, and disabilities is absolutely high on that list. Developmental Disabilities Assistance Act followed. Protections and Advocacy for Individuals with Mental Illness Act went after. Certainly Fair Housing Act, and you can see kind of through the development of these laws, it started impacting just different spheres, right? It went from education to employment to living. And if you think about it, there's a spectrum of services and areas of our life, and as the government, as laws develop, they typically start in one area and gradually spill out as somebody advocates on behalf of that sector. American with Disabilities Act was really the pivotal, 1990 under Bush. Ticket to Work and Work Incentive Improvement Act, that one I have no idea, because the first time I saw that one was when I saw this slide. Help America Vote Act, I knew it exists, but again, never read it, don't know much about it. The couple things that are not on this list that I would put the presentation together, I would absolutely include FMLA. That was a tremendous advancement, right? Because it doesn't just protect the person impacted by a disability or a condition, it also protects their family members, right? And that's critical. Say at some point Chris wants to, my husband Chris, wants to get a guide dog, and it requires, extensive time being away from home, and I happen to be employed in a place that is covered by FMLA, I as a wife might have rights under FMLA. I just need to engage with my employer. So please remember, please keep it in the back of your mind that all of this doesn't just affect the individual with a disability, but perhaps those that care for them. American Disabilities Act, ADA, protect civil rights of people with disabilities, signed Bush 1990, definition of disability broadened in 2008. It is like a living definition. Those of us who are not practicing lawyers, they think that something is illegal. It's just ubiquitously illegal, right? But we're actually governed by state laws and federal laws. Typically, if the two things have to do with the same area, federal laws will preempt the state laws. But understand the definition of disability may vary. The goals of ADA, you know, we can certainly put it in black and white, but we understand what the goal is. The goal is have some enforceable standards that people understand, that employers understand, that creates an even playing field, fairness to individuals, businesses, and the government, independence and access, a diverse, integrated, and welcoming society for people with disabilities. It's a bit of a pipe dream, really, but you know, we at least can have laws that make us, once we read the laws and understand the laws, make us think that we're better people and the rules of the game are really going to be more fair. It is intended to protect the civil rights, and as I mentioned, there is no civil right to work. There's no civil right to be employed. Right? At the end of the day, it's an at-will arrangement between an individual and a particular company. Signed in 1990. Like I said, the definition is kind of a living organism. It expands as our understanding of disabilities and understanding of what makes people different and what requires employers to make accommodations. That also is kind of, it's not set in stone. Go backwards. I'm going backwards. All right. Employment. Title I. Employers are not allowed to discriminate against individuals because of a disability. It doesn't guarantee an individual a job because an individual has a disability. You must be able to do the job hired to do with the duties and accommodations. And you can terminate a required for the job even if you have a disability. Oh, I need to do that. So you can take it off.
Why don't you just hold it?
Yeah, there we go. A lot to digest here. So I will tell you, and this is a really, I'll try to give you, you can all read the slides, or some of you can, but I'll read the slides. I'll give you kind of a practical aspect of this. How many of us, when we got our job, we also got a job description? Youngsters? All right, I'd say about 30%, right? For the most part, you apply for a job, there's a list of requirements, you think you hit some, all, you go through interview process, you get hired, right? But there's really no one who says, okay, here are the 20 things that you're required to do every day. We're all adults, we are professionals, we understand what's required. So it's very difficult to really, when you have a disability, to understand what exactly are my job requirements, right? Because the accommodations will be closely tied to those requirements. You know, how will an employer measure what you can and cannot do because of a particular disability? So my kind of, you know, forward thinking when you do get a new job, perhaps putting things in writing, perhaps better defining and understanding what your role is, whether it's a, you know, requirement for hours, whether it's a requirement for, you know, you review certain things, how many things you need to review per day. Putting guardrails, right? Putting better defined terms will make it easier later on, especially if it's a disability like choroideremia that is progressive in nature and you really don't know what the pace of it is. You can always kind of give yourselves kind of tools, right? Think of it as a toolbox, right? Give yourself some tools and some things in writing. I'm not suggesting you begin a conversation on your second day with HR that, hey, by the way, I have a disability, and 4 years from now I may not be able to do this. I strongly advise you not to have that conversation. But there are ways of saying, okay, I want to make sure I'm doing my job right. I want to understand what the benchmarks for advancement are. Where do I want to be in 5 years, right? That's the kind of dialogue that will be really helpful moving forward. Sure, I'm moving in the direction.
The definition of when they have reasonable accommodations, you know, when it said with or without reasonable accommodations, it's kind of, what do they define as reasonable?
So reasonable accommodations, again, much like the definition of disability, it's a fluid process, right? The employer, even more so than giving you a reasonable accommodation, before you even get there, they have to engage in what's called an interactive process. And that's where there's a lot of give and take. And that's where you have a benefit of getting an advocate or a professional or a physician who says, here are the things that you can do. And hey, let's take a look at the list of your requirements that you have to do, and what can an employer do to accommodate that, right? Say it's a condition of your employment that you drive, that you have a valid driver's license, and you're a FedEx driver, you're a delivery driver. I'm going to say driving is probably a pretty important part of your job. So if at some point you can no longer drive, it's probably unreasonable for an employer to provide you a driver so you would be performing your job. But any kind of adaptive technologies, and we had a dynamo earlier today about adaptive technologies, and being a self-advocate and learning about adaptive technologies, certainly if there's something out there that's going to make you do your job easier and an accommodation will enable you further to do your job, that is absolutely a reasonable ask.
That could be for HR or something as simple as additional lighting in your workspace.
Absolutely. Absolutely. I would actually call on Andrew just like a briefly, like what are some of the reasonable accommodations that you've seen in your practice?
I run HR for a music publishing company for our North American region, and I've been asked for more desk space, more lighting, as Correa said, has come up. When it comes to reasonable accommodation, one of the key factors that I, as an HR person, look at on behalf of the company is it an undue hardship? Is the request so severe to the company that it can't be, maybe it's too expensive, maybe it requires construction of something. So, perfect example, the most recent thing that we've had was we have a woman that has just given birth, and she is required to come back to work in the office, but we have no lactation room. Most states require that there are lactation rooms. That requires us to build an office or a space. We, don't even have the physical space to do it in our current office, so that is now an unreasonable hardship. So she's now able to stay at home until she is done lactating. So we are not penalizing the employee, we're just saying, we can't do it here, so we're going to make some other accommodation.
Is there like a benchmark cost to like size of the company or revenue or something that is used? Because reasonableness always seems to be like the tricky part of that.
Right. There are so many different factors. If someone came to me and said, I need X, Y, Z, and I just spouted out, well, you know what, we can't afford it. That's not going to hold water. And most likely, a good individual, a smart individual, will seek advice from a legal professional if it's really something that they need that maybe is too expensive.
I'll give you an example. So what's important about this slide is that ADA applies not just while you're employed and when you're employed. It's also in the hiring process and the promotion process. So it's very important that if you cannot be discriminated to even get the job on the basis of disability. There was a case of a young gentleman who was born deaf. And it's kind of like the textbook case that I think all of us who does employment law knows about. He was born deaf. As a teenager, he went through a lifeguarding certification. He had a cochlear implant. He could not speak. He used sign language. He applied for a position to work as a lifeguard at a county pool, and they just dismissed him outright. They said, there's absolutely no way. This is not safe. We don't want a deaf person on the stand. We're worried that somebody's going to drown. They brought a discrimination suit. They threatened to bring a discrimination suit. The county went ahead and did a medical examination, and unfortunately, the physician was very dismissive. He didn't even look at the kid. The kid walked in, he saw the implant, like, there's absolutely no way, you're deaf, you cannot be a lifeguard. So it wasn't even the process, right? It was just awfully hard experience for the kid. The county went then ahead and hired a consultant. They realized they've messed up, and oftentimes, companies will have a knee-jerk response that's clearly illegal, and then they would try to kind of clean things up. They got a consultant who interviewed the boy, who watched them a little bit, and then came up with the same determination that there's no way, we're not making any accommodations. And the accommodation they asked for was an interpreter. He already had an implant, so he could hear, right? He just needed somebody to verbalize his advice, or if somebody needed help, he needed somebody who could explain and speak for him. It went through the state court system, and the states sided with the county, which does happen quite often. To the same, right? When it went up to the federal court, the Sixth Circuit reversed. And they reversed because they said, listen, they had their own experts, and at that point, the board had experts. And it turns out that there are quite a few deaf lifeguards out there. And their rate of saves is significantly higher because they pay attention to them. And they're much more attuned to somebody waving in the pool that they're drowning. So they're not relying necessarily on their ability to speak or the ability to hear. They simply pay more attention than folks who have suppressed their senses. So Sixth Circuit reversed, and that's become kind of the gold standard. So something like providing an extra person who's already on deck anyway to simply give these interpretive services to a deaf individual was not an unreasonable accommodation. ADA definitions. A qualified person who has a disability with or without reasonable accommodation to perform the essential functions of the job, and that you'll see that essential functions, right? That we go back to, like when you get a job, you really need to understand what it is that you need to do to be a fully functional employee. Disability is a physical or mental impairment which substantially limits one or more major life activity, or is a record of such impairment, or is regarded as having such an impairment. Again, it's a living definition, and it's often a good idea to have a conversation with your treating physician, the ophthalmologist, or anybody, to kind of understand what those limitations are, right? Again, we talk about the toolbox, because when you have a progressive vision loss, when you have a progressive condition, you have a disability that's just kind of an ongoing thing that you may at some point need a measure of accessibility and accommodations and assistance. It's good to start putting those things in writing and keeping a record. Essential function, a job requirement that is vital to the job, and if removed would fundamentally alter the position. Now that's an interesting one because I've seen instances where somebody did not get a promotion. They raised the issue of a disability subsequent to that, and then there was an opening in the company that was not lateral but slightly higher, and we worked very hard with the individual, and it just so happened that the function of the job changed, and that was like a perfect fit. So, sometimes we talk about, silver lining a lot. If you're finding yourself that you can no longer do the job without an accommodation, perhaps there's another position in the company. And again, much like they cannot hire you because of a disability, they also cannot deny you a promotion because of your disability. Reasonable accommodation issue. You may never have to tell your employer about your disability, but if you need assistance to do your job, then you'll need to tell your employer about disability to get the assistance you need and why the disability requires assistance. Of course, right? You need to engage in what I put lawyers what's called an interactive process. At some point, you're going to need to tell them something. Now, about that something, you don't have to give them your full genome, right? You don't have to say, I've got an X link and here's where it is. In fact, one of the laws that wasn't listed, and I forgot about it, is GINA. GINA is a genetic information. You have your own privacy. That is your information. You cannot be compelled to provide that. So again, engage an attorney or a friend who's an attorney or your physician and kind of figure out what is your elevator spiel about why you need this particular accommodation. You don't need to, again, give them your entire medical history. They have no right to that. They just have a right to that little segment of what it is that makes you unique and requires accommodation.
And if I could just add, put it in writing.
Put everything in writing.
Put everything in writing, and preferably in a way such as an email where you can prove that it was sent.
There's some easy things. I mean, we advise clients all the time, right? Send your email and say, can you please confirm that you received my email, right? The other thing, when somebody calls you and says, hey, I want to schedule an appointment, can you please put that in writing? So this writing requirement is not just what you've told your employer, but it's also the stuff that's coming back. right? If they want to get you in a room and they're going to give you all this stuff and you're already stressed out because it's uncomfortable and you're sweating and your job is on the line and it could be very, very intimidating. Take that pressure off. Say, I want to see this in writing. They cannot say no.
And sometimes you'll find your employer's been waiting for you to say something so that you can help.
Very good. You never know. What is a reasonable accommodation? We talked about that. A reasonable accommodation is any change or adjustment in a job, work environment, or the things are usually done that would allow you to, whether apply for a job or perform essential function or enjoy equal access to benefits. We talked about a few examples, some practical things, whether it's restructuring, whether it's some time off, whether it's flex work, whether it's working from home because you can, accommodate better writing, etc. Appropriate adjustments or modifications of examinations, training materials, and policies. Let's say you just need something in larger print, right? It could be something as simple as that. Breaks to take medication, lactation issues, yep. Someone to drive you to meetings or other work-related events. That's where, when you're starting to impose, when it takes another person to either do your job or make sure you're doing your job, right? That's where the burden, that those scales become a little bit iffy. And that's where communication is critical, that it has to be an interactive process. Don't ever be afraid to ask for anything, because the worst that can happen is they'll just say no. Driver's license. Yep. If driving is an essential function, doesn't have to eliminate that from your position. Just gives other examples. So scenarios, driver's license. A qualified sales clerk applied for promotion to assistant manager of a store. The employer promotes someone else claiming an essential function of the job is driving store receipts to the bank. Because depositing the receipts, not driving, is the actual function of the job, the employer should have determined whether the sales clerk could have done the job with a reasonable accommodation. For example, having another employee drive them or paying for a taxi. I suspect they probably won't pay for a taxi, but if you can do it electronically, there's absolutely no reason why the deposits cannot be done electronically, eliminating the entire driving requirements. There are just lots of different ways to skin a cat. You just, again, and I keep repeating myself, it's an interactive process. Take full advantage of that. It builds a record, whether your employer is reasonable or unreasonable, and at the end of the day, that's going to, if you do have to go to court, that's going to carry the day. How do you request a reasonable accommodation? There are no magic words. Let your employer know that you need an adjustment or change because of your disability. Put your request in writing. Request should describe the nature of disability, the resulting limitations, and the need for an accommodation, and the proposed accommodation if known. I am a big believer that you hold the keys to your own kingdom, right? I think when you work, you know what makes it possible, you know what needs to be done to make you more efficient, to eliminate the effects of a disability. I always counsel my clients to come up with a proposal, right? There needs to be a starting benchmark, right? This is not an issue where we're playing poker and you don't want to put your bid first because you don't know what's going to come back. It's a very different scenario, right? This is not a zero-sum game. At the end of the day, the goal is for you to be successful at your current job with some reasonable accommodation. So, take your first shot at that. Interactive process. After an accommodation is requested, the employer, employee, and other relevant personnel should enter into an informal interactive process. Employers may request limited medical documentation, very true. They may even request that you submit to their physician's examination, and that is not an unreasonable request. The process should take a reasonable amount of time, and the duty to accommodate is ongoing. So from the time you kind of wave a flag and you say, hey, I have a disability, I need an accommodations, here's what I would like to see happen, it starts, the process starts. Reasonable accommodation limitations. An accommodation does not have to be provided if it's unreasonable, requires reallocation of essential job functions. As I mentioned, if there's going to be another person who will have to either do your job or make sure your job is done, that will tip the scales of what's reasonable. Will not enable the employee to be qualified. It results in undue hardship to employer or results in a direct threat to the health or safety of the employee or others. That last one is what the county used to deny employment to a deaf individual. And the court said, absolutely, he is no threat to either his colleagues or the folks. Reasonable, when you talk about reasonable, it's like beauty is in the eye of the beholder, right? Most of these things are going to be jury trials. There's going to be, you don't need to convince a lawyer or an employer to convince the 12 folks. Enforcement of Title I. You file a complaint with Equal Employment Opportunity Commission within 180 days of the alleged discriminatory act. Every law has its own statute, right? There is a timeline, a predefined timeline that puts kind of, timestamps on when things have to be done. Oftentimes, you cannot just sue your employer, right? There is a right to sue letter that another federal agency needs to first issue. So, as I mentioned before, do contact an attorney, because these days, you think 108 days is a long period of time. It's not, right? Especially when you're managing family, work, etc., and going through this process, and perhaps fear or worries about losing your job. Talk to somebody who will give you the roadmap. There are different deadlines for federal employees, age discrimination, equal pay. There are also different deadlines on a state level and federal level. Court process and possible remedies. You may request a right to sue letter 60 days after filing with any of the agencies listed previously. We had a CRF family who went through that process and kind of came out on the other side beautifully, getting a new job. So we have some. If anybody in the crowd is interested, reach out to me and I can put you in contact with some folks who've lived it, and that's always kind of the best insight. Possible reliefs at various levels include equitable relief, hiring, promotion, reinstatement of position. I will tell you that one is inherently unrealistic, because if you've threatened to sue or sued your employer, your chances of reinstatement, and I'm not quite sure we're going to ever want to go back to that place. So, perhaps in some perfect world that might happen and everybody will wake up tomorrow and forget what happened. After you sue somebody, odds are you're not going to be, inviting each other to dinner. Damages. Oh, go ahead.
What about being blackballed in your business? Is to sue your employer and then you go try to find a similar job with a competing firm, but they've already talked to your former employer?
That is business libel or defamation. If you can prove that your current or former employer said things about you to a prospective employer and those things are untrue, they would be liable for damages for a variety of that works.
But the challenge is proven, right?
It's always a challenge.
Discussion.
I will tell you that it's always a challenge. Oh, God, great. Yes, sir. Your Honor.
We'll finish the answer if you want.
No,
Actually, it's not.
Much like this is like a
It's not actually maybe Brett do, but get him in.
Andrew.
I work for a state agency. I have 35 employees. The trial court has lots, and I use obviously their HR.
Right.
I'm sister had polio. I have 2 sons losing their eyesight. I'm fairly sensitive to accommodation. Do you find, because I've got some accommodation abusers who are coming up with requests, and basically they don't want to go to one of my 3 courthouses. How rigid? At certain points, there are accommodations you can make, right? They're probably not going to hurt you at all. They're easy to do, but they're complete bullshit. So how do you, as an HR, weather that storm and you put up a good stand when you know it's...
My personal experience in that is, if the accommodation is minimal, and it really does not impact anything, it doesn't impact other workers, it doesn't impact budget or anything like that, most likely the request is going to go to your manager first, and they're most likely going to say, yes, that's fine. I need to be able to work from home more than I'm working in an office. And this is before COVID, right? They'll most likely, as long as you can do the job, they'll be happy with that. It's when it starts to get excessive from the same person, now I need this accommodation, now I need this accommodation, that will tip the HR person to say, let's go through this interactive process and figure out what is really needed. Because maybe, and we're not discounting that the accommodation requests are bogus, but maybe it will impact the essential functions of the job. And therefore, we may have to see about putting the person in another position, a similar position, or coming up with another strategy altogether. It's every single accommodation request is a case-by-case basis, and I don't think I could do justice here by just giving a blanket answer to that, because there's so many different factors that will come into play.
You sound like HR.
Every 2 years. Going back to the other thing about being blackballed, it's not just from the company, it's managers, co-workers. If you're working in an industry, they reference checks to me are bogus. It's because people will already contact their co-workers, former co-workers that may have worked with someone, and they already know about you before you were even given the job interview.
And I will tell you, yes, proof is inherently difficult. Fear is unreasonable, and it drives people to do reasonable things. You know, a demand letter to an employer with a litigation hold will go a long way. And they'll have to disseminate it to their employees, and they'll be like, oh shit, I put that in the email. People put a lot of really inappropriate things in the emails. So oftentimes, just kind of a shot across the bow might get you where you need to be. And you know, and it's not a bluff. Like if you have a claim, you can certainly send somebody a litigation hold, and all of a sudden they have to pay for a lawyer, and somebody has to read it, and they have to review their document retention policies, and it becomes a process on its own. And you know, and then your manager has to do the compliance, and that's a whole. There are ways, right? There are ways. All right. Oh, wait. One more thing here. Damages, right? Because we know we're not going to go back to that employer. We're not going to work for them. So damages become critical. They can be compensatory or punitive. It should be and. Compensatory is just your lost wages. Punitive is how badly did they really act. Like, did they send you to a doctor who didn't want to look at you, right? Were they insulting, or did they mock your disability? And unfortunately, it happens. And it plays terribly to a jury, right? It tells a really bad story. Fees, attorney's fees, experts, and court costs. It depends on the jurisdiction, it depends on the statute typically. Unlike other legal processes where we have what's called an American rule, where each litigant, plaintiff or defendant, they pay their own fees unless, you know, lawyers do something terrible or clients do something terrible. Here, courts are very lenient, statutes are very lenient, and they will give you attorney's fees. Yes, you have to go out of pocket, but if you do prevail, there are ways of recovering, of making you whole. Because this is not something we want to dissuade people from doing, right? We don't want to build in an institutional disincentive to people to vindicate their civil rights, right? So courts do award attorney's fees, and you will see court fees and expert fees awarded to a prevailing party, plaintiff. Title II of the ADA. So everything that we just talked about that applied on the federal level, now bring it down to the state where you live. And the laws may change. Typically, they won't give you less protections. They will give you more protections. And this is, you know, federal level gives you a bucket, and then your states can give you more, but they cannot give you less, and that's because federal law typically preempts state law when it deals with the same issue. How the ADA applies to state and local governments. It prohibits discrimination against qualified individuals with disabilities in all programs, activities, and services of public entities. Transportation, access to court system, voting, education. All of the state services that state provides, they must provide with accommodations if you need them. That's Title II. And as I said, it covers public transportation. A Supreme Court case. Two women, Louis Curtis and Elaine Wilson, who had mental illness and developmental disabilities, were voluntarily admitted to a psychiatric unit in a state-run Georgia hospital. Following the women's medical treatment, mental health professionals stated that each was ready to move to a community-based program. However, the women remained confined in the institution, each for several years after initial treatment was concluded, due to state budgetary concerns. Well, that's imprisonment. Just because the state can't afford something doesn't mean they still don't have an obligation to provide it. It's an unjustified segregation of persons with disabilities. It's discrimination under Title II. Public entities must provide community-based services to persons with disabilities when such services are appropriate, clearly here appropriate. The affected persons do not oppose community-based treatment, and community-based services can be reasonably accommodated, considering the resources available to the public entity, the needs of others who are receiving disability services from the entity. There are not that many Supreme Court cases on disability. This one sticks out. There are a couple, and typically what it does is it takes a legal principle that applies in one area and applies it, kind of a watershed effect, applies it in a next sector, be it housing, be it employment, etc. The decision led to huge changes to how services are delivered to people with disabilities and remains a great tool to push for integration. Enforcement of Title II. Private lawsuits, courts order to stop discrimination, attorney fees, no monetary damages. Makes pursuing a case very difficult. File a complaint with a designated federal agency, typically Department of Justice or Department of Transportation. When you file at the federal level, damages may be available. Title III is your public accommodations. And this applies to private entities that own, operate, or lease a place of public accommodation. So commercial facilities, hotels, restaurants, movie theaters, educational facilities, universities, schools, even private schools. We've had instances where private schools are refusing to provide ADA accommodations. Well, guess what? You can pull up, a lot of private schools, institutions are 501c3s. Their tax records are public. You go look at their tax filings and you see that they receive any federal funding, and if they receive any federal funding, they are subject to the ADA. That's really kind of the litmus test there. It includes a wide range of entities, restaurants, hotels, theaters, physician offices, daycare centers. I mean, really think of anywhere where public is welcome. If public is welcome, so do folks who are different. Examples of discrimination in Title III. I'm sure anybody here who's been at the airport with a visually impaired person can give quite a few examples of those instances. Again, are you going to redress all of them? Probably not. It's just not realistic. So, you have to kind of know which battles to pick. No child in swim diapers may swim in pool. Again, not my slides. I'm just reading. It's true, though. What does Title III not require? It doesn't require modifications that would fundamentally alter the nature of the service or an undue burden. No discrimination for a physician who specializes in burn patients to refer a patient with a disability to another physician for a broken limb. It's outside the specialty. Not all restaurants must have Braille menus if waiters or other employees are available to read the menu. You know that. I can't tell you last time I saw a Braille menu. Anybody?
I've been offered Braille menus.
We were Chris and I just traveled. We were offered a Braille menu.
So our first date, we went to a restaurant that was basically a backlit menu. So it was before iPads, basically. It was basically like a giant iPad as a menu.
And that's when I asked him to marry me.
She couldn't see anything anyway for the rest of the day. Retail stores not required to have sign language interpreter on staff if they communicate by pen or paper.
It's reasonable accommodation.
Existing facilities and barrier removal. Physical barriers to entering and using existing facilities must be removed when readily achievable. The yellow cones that are everywhere, right? You guys can find them brilliantly. Readily achievable means easily accomplished and able to be carried out without much effort or expense. So you can certainly install ramps, make curbs, cuts at sidewalks, which I actually...
Or even sometimes you're in those long line queues,
Oh yes, the serpentine of the TSA.
And you'll see people come over sometimes here, and just let you go through. I mean, it can be something as simple as that, which is great.
Yeah, but that requires the rest of the world to pay attention, right? And we all know that everybody's distracted; they're on their phones, but there is an occasional person who will do the right thing.
Can you ask? Because but if there's nobody in the line, we're just doing this thing.
Oh, absolutely
There you
not.
go, excuse us, can you just
Absolutely.
do this thing?
Absolutely.
Or just undo them.
Yeah.
Let them have running.
I don't know if you had advised to do that in the TSA, because they might just ask. I think if you advocate, a little bit of self-advocacy will go a long way in all of those situations, because if you just say, hey, my husband cannot see, or I cannot see anything of me. I think, I gotta believe that most people will accommodate and will help. I did not put together this slide. I don't know what it's supposed to mean, but I suppose the things that are clearly not compliant. Alternatives, if not readily achievable, if the accommodation cannot be made, alternative steps may be taken to make goods or services available. Provide goods and services at door or sidewalk. Provide home delivery. Retrieve merchandise from inaccessible racks. Relocate activities to accessible locations. I did not see in this presentation talk about web access, and we've got some folks who are experts in that. Sheldon, anybody needs about web accessibility? Absolutely. There was a case in the United States about somebody trying to order pizza. I can't remember which
Domino's.
Domino's, thank you.
Shut them down.
They sure did. They sure did. A visually impaired person was not able to order pizza using their website, and they took it all the way. I mean, and that's the thing, right? As an employer, as a restaurant, as a chain, we're all concerned about public image, and they're going to take that issue all the way to the Supreme Court.
They did.
They did.
Yeah,
They did.
Domino's did. They didn't want to fix their website.
No,
They lost.
They lost. It would have cost them about $25,000 to make an accommodation and to change their. Yeah, I heard they paid $6.5 million in legal fees. New construction or alteration. New construction must be accessible. Alterations must be accessible to the maximum extent feasible. Must follow ADA accessibility guidelines. These standards include general design requirements and building and site elements such as parking, accessibility, routes, ramps, elevators. I think that, yes, certainly for folks whose mobility is not compromised, those are all great things, but if you can't see the sign that tells you don't go there, that's not really a good accommodation.
One recent improvement I've seen in newer buildings, because it used to be under the ADA, the water fountains had to be accessible, and that was great. They had them so they were sticking out from the walls, so someone with a wheelchair could get under it. But someone with a cane would walk right into it because the cane went under the water fountain. But newer buildings, they now have recessed alcoves with the water fountains, so the water fountains aren't sticking out into a walkway. So those types of things are getting there, which is nice.
Honestly, I think it's going to take a long time to catch up. The need for accommodations will always be behind, or the actual accommodations will always be behind the actual needs. So, how to file a complaint for Title III? They are private lawsuits. Court can order the discrimination to stop. You may be able to recover attorney's fees, but no monetary damages. Again, if you really want to prove a point and correct something for the benefit of the community, go for it. File a complaint with a designated federal agency, typically U.S. District Court, because it's a federal issue. And there's no need to first kind of jump through hoops that you would otherwise have to do with, for instance, an employment issue under the ADA, where the state and the government really wants to make sure you have a viable claim. Right? To Tom's point, sometimes those accommodations are just flat out. I had one of my very first cases 20-some years ago was this woman who was allergic to strawberries. She wanted to ban strawberries in the office forever and ever and ever. And things happen, right? People have requests. U.S. Department of Justice, you can file a complaint and proceed, or instead proceed directly with the court. One of Chris and my dear friends was for over 10 years worked for the Justice Department in the education equity and has had some great stories. My recommendation, if you can get the government on your side, as just a litigation strategy, it's always a good idea to have somebody else fight your battle who's got much deeper pockets and much more at stake. I find calling regulators when you can use their muscle a great way to go. And, again, it's one of those tools that you have, much like a strongly worded litigation hold letter because you just want to hold somebody accountable for the BS that they're doing. Service animals. Dogs are the only recognized as service animals, though revised regulation also includes separate provision for miniature horses. I did not put this presentation together or fit that. I had no idea, but I did see an iguana at Dallas Admirals Club. Somebody was like walking iguana with as a service animal.
Guide horses.
I've never seen a guide horse. Anybody? I've never seen a guide horse. But it is amazing how surprised people are when you see somebody with a service animal, with a dog. You know, there just needs to be a lot more, I think, education of general public that these things are, that this is what's happening. Title II and Title III, entities must follow service animals in all areas where members of public are allowed to go. Must be under control of their person. Only 2 inquiries are allowed. Is the dog a service animal required because of disability? What work or task has the dog been trained to perform? So again, that just kind of limits some communication and conversation. If folks want to ask all sorts of other questions, like, you know, what's your favorite color? What's the dog's favorite color? Like, why is the dog here? They really, you don't have an obligation to respond. Those are the only 2 things you need to identify if that is a service.
They can ask that question?
I'm sorry, I didn't hear.
That question can be asked?
Those 2 questions can be asked.
Really?
Some examples of what the dog might be trained to do: guiding, pulling a wheelchair, alerting persons who is having a seizure, reminding to take medication, and calming a person with PTSD or anxiety.
Is that
Lots of resources. Thank you. Before coming here, because FMLA is not covered, I pulled a little cheat sheet, and I'm happy to make copies of this. And this is just ADA versus FMLA cheat sheet, and I'll just run through it. Very quickly, if you find it helpful, please come up and take a picture with your phone or whatever. So ADA prohibits discrimination against individuals with disabilities, right? Whereas FMLA provides leave to the impacted person as well as their family members, and that can be critical for some of the folks here. Who is eligible? ADA, individuals with a qualified disability. FMLA, pretty strict. Employers who have worked for the past 12 months, and that has to be full 12 months and 1,250 hours. Employers, with at least 50 employees. The time period starts when you ask for an accommodation for leave. So let's say you've been somewhere for 11 months, but you know that your spouse will be going to be training with a service animal in 6 weeks. You can kind of lay the groundwork because your leave won't start until you've been there for a full year and you qualify for FMLA. What conditions are covered under the ADA? We talked about disability, and it's a really fluid definition, anything that impacts one or more activities of your daily living. FMLA needs to be a serious health condition of employee or certain family members. The typical ones are the birth, adoption, big life events, but there could be much smaller events that are have serious health implications that will trigger your FMLA rights. What leave is required under the ADA? Leave may be a reasonable accommodation for a short period of time, but obviously, as we've talked about, there's this balance with the requirements of your employment. FMLA, it's up to 12 weeks, right? So at least you know how much runway you have if you need to take the full. It's unpaid. Benefits. ADA, there are no...
Is that 12 weeks over what period? What if somebody took 12 weeks of family leave and then a month later turned around and applies for more?
Yes, I believe it's 12 weeks in any 1 year period. Tom, do you know the answer to that?
I think that's it. I have someone.
Yeah, it doesn't have to be continuous. It's a rolling 12 months. It doesn't have to be continuous. So you can take 2 weeks and then take additional time as needed.
And some states have different rules. Massachusetts, for example, has other stuff.
Yeah. Some states have up to 26 weeks.
Right, so FMLA is a federal one, but then they also have, many states have their own as well, which will always be greater, not less, like you said earlier.
Under the ADA, what benefits, there are no specifics, you just continue with your accrued benefits, deferred compensation, whatever the benefits are. FMLA, the benefits typically do not accrue. So for instance, for seniority, your employer can tag you for the time that you took away. So let's say you need to be somewhere for 2 full years to qualify for promotion. In those 2 years you take an FMLA, that means you need to kind of, pay that back. Reinstatement. For ADA, if B was part of your reasonable accommodation, certainly they don't have to reinstate you. For FMLA, they must reinstate you to the same position, to the same, so they cannot discriminate against you because you've taken a leave. Light duty, sometimes it could be a reasonable accommodation, kind of lighten the load, or perhaps transition to a different position. With an FMLA, the employer cannot require you to, can you just do it part-time? Do you mind doing it for a few hours here and there? If you're taking FMLA, you're off the clock. You're not getting paid, you're off the clock. And the not getting paid is really a matter of how long you've been there, how valuable that's an interactive process. And potential penalties, certainly for ADA violations, we talked about, there's lots of them, right? There's back pay, compensatory damages, punitive damages, attorney's fees, costs, experts, etc. FMLA, it's definitely back pay, it's reinstatement of benefits and attorney's fees. But because it's a much shorter duration and less of an impact on your life, it's much more. Questions? I don't know how much time I have. 9 minutes.
I'm waiting.
Jeff.
Yes, first of all, thank you for putting together such great slides for us today.
Thank you. I slides, especially the miniature horses. That's going to be the first thing I do after this. I'm going to Google miniature horses.
Our friend rescues them, and we just took a picture of that because she rescues miniature horses.
And she posted a picture of her walking a horse, checking in at the front desk at a hotel. She wasn't really going with the horse, but it was kind of a joke. But she could have, All
right, Jeff, what's up?
No, I'm not sure, this might be more HR than legal, but with the two of you, I figure it'll just be helpful a little bit, maybe out of scope of here, but I have a company that their disability that they pay for, their disability insurance is really good, but the company themselves almost don't, I don't worry about the company so much as I do the insurance company that covers the company. So I'm not sure who my friend is in this relationship. So if the way that it reads in the benefits handbook is when I feel like I'm disabled, I call this number, which is the insurance company. I feel terrible if I just one day wake up and call the insurance company and don't give my employer heads up that this is happening, but I almost feel like maybe that's the proper route. Do you have advice on what the proper route would be if I do indeed feel like I finally reached that point that I want to go on disability?
Yeah, I wouldn't so far as to say it's a proper route, but here is what I would do and here's what we have done, what Chris and I have done, right? Employers on your side, insurance company is not, right? There are different causes of action that will arise for a breach of contract against the insurance company if they're playing games with you and do not want to pay out the disability. Whereas as the company, as your employer, it's the term of your employment to have access to disability insurance. So employer has a lot less on the line and they like you and you've been employed there, and obviously that's the benefit that they provide to their other employees. So if you have a problem with that and they're dining you and being difficult, right, with you, that sends a wrong message. So absolutely, my advice would be to engage with the employer first, because they will also be the ones helping you through the disability process by telling the insurance company, he can no longer perform this, right? Disability contracts are written either for a specific position or kind of globally, right? And some are more expensive than others. Again, it's a contract. One thing you need to do is you need to get your hands on that contract and either you yourself read the contract or have a lawyer read the contract to understand exactly what is covered and how disability is defined. Because you may no longer perform the essential function of what you're doing, but if your contract defines it as, well, perhaps you can find a different job elsewhere, they will absolutely kind of try to stick you with it. I'm going to air dirty laundry, and Chris, you can speak.
How dare you?
Your husband was in the back of the room. But you can also engage a physician If you do have that policy specific to your position, you can engage a physician who will, write a report and say, here's this disability that this person is experiencing, here's how he's disabled and unable to perform these specific function. Write it to the contract, but always read the contract first.
Okay. Last comment real quick. I just for the people in the room, the combo, the voice back here and the voice up there, Lisa and Chris, what they have done for this organization has been astronomical. So those two people that you're just hearing are just the foundations for this company for a very, very long time. So thank you guys.
I just want to add one thing about, as a design engineer, the ADA accessibility guidelines have a certain effect on what we do, designing things, but for all the men in the room with choroideremia, you go into a public restroom and the urinal is hung on the wall at a height for Tyrion Lannister or Frodo Baggins.
Yes, sir.
Listen, to your point earlier about sometimes just a letter will get the right result. I had a company I worked for one time who was purchased by another company, and they were doing a series of layoffs. And so when I was one of the people being laid off, and I talked to the manager who was discussing all this, and when I asked, why was I chosen, versus other coworkers or whatever, and he basically started talking about that. He listed all these things and said, well, you just don't do your work as quickly as some of your coworkers. So I said, so you're telling me because of my disability, I was chosen? And he's kind of like, yeah. And so I had a friend. So I got
Do you own that company?
a friend who was an employment lawyer, and we just sent a nice little letter, and the remedy was much better than the severance. So, anyway. But it was one of those things where they're stupid enough to admit it, and I just go, I could have just walked away and said, just forget it. But I'm like, it just made me mad that they were stupid.
No, and then, my plea to all of you is please advocate, right? Advocate for yourself.
Just because you might even work for a big company that's tens of thousands of employees does not mean they're not being completely stupid, ignorant, and insensitive.
Oh, stupidity has no, it doesn't discriminate.
Can't teach them.
Yeah. Can I ignore that one?
No, you can't ignore me. Maritally required. I just wanted to make it just an addition to the comments you made towards Jeff, about how to approach the employer versus the insurance provider. And I think, the thing to consider is that, when you go to your employer to engage in that conversation about, hey, I may need to file a disability claim, you also are, you're essentially opening the opportunity to then have that discussion and to talk about reasonable accommodation. So it is something you need to think about a bit in advance. That are you looking for accommodations, or what are you looking for? Are you potentially opening the door to talk about a job performance discussion, which could depending upon the employer could be the outcome of that discussion. And it gets difficult. I mean, Jeff, I was in a similar situation I think that you're describing, where I wanted to tell my employer in advance when I was leaving emergency medicine and wanted to kind of give them advance notice, but it gets a little challenging as an emergency physician to say, hey, my eyesight sucks, right? What's the responsibility of the employer at that point to then say, well, hold on a second, should we keep you employed at this point in time? So it's just something you also have to think about sort of thinking through when you open that door, what is the outcome of that conversation? What are the follow-up discussions that you may inevitably have, or the employer may want to have with you. And I would give a plug for, we're talking about insurance. I know that's kind of a parallel to this conversation, but certainly those of us with choroideremia, if you are employed with a company that provides disability insurance as a benefit, take advantage of it. There's often opportunities as well to pay your premiums by yourself instead of having the employer pay your premiums, which makes means your benefit will be tax-free on the back end of that, and it's something you may want to discuss with your employer. Oftentimes it requires a little bit of a buy-up in your policy. I will tell you that if you're looking for individual disability insurance, good luck, Godspeed. You probably can't find it because you have CHM. But again, take advantage of that benefit. You may never need to use it. Hopefully you don't. But as as a downside of your eye disease, or potentially, as you heard JR talk about earlier, falls and injuries and things of that sort, it does provide you with additional protection if and when something were to occur.
I'd like to say something. I used to own my own company, and I had thanks. Oh, sorry. Oh boy, now you can hear me.
Yeah.
So I used to own my own company, and
Did you make a reasonable accommodation for employee agreement?
I did. I did. And what happened was when the company had to close, so I said, okay, I had this group plan, and all my life I was thinking I was going to be able to claim on the group plan because I couldn't work anymore. The insurance company told me that I didn't get a doctor's note, and that I couldn't get the claim stick because I had done my job, my essential job, for even a few years. Even though I couldn't do it very well and perfectly, even to my own standards, I kept doing it because I own the company. But the insurance company ended up telling me that you didn't have a doctor's note, we don't have to pay the claim. And they didn't. Thank you. So I suggest you get a doctor's note. Worst comes to worst, it doesn't matter. But
And there are physicians who do this, whose specialty is, what's the name, Chris? There's a specialty that compares the disability with the job description and gives you a note that looks, feels exactly to what the insurance company would look for.
I'm drawing a blank, but there's vision centers typically tied to the places where you get orientation and mobility training and such, and sometimes they have physicians there that do these kind of evaluations, partly to give you an idea of what accommodations or technology can support you, but they can all potentially also can kind of give you that additional evaluation to say, no, you shouldn't be managing. You shouldn't be driving that FedEx truck based on your visual, your visual function, and here's my recommendation as a physician. So I mean, I don't remember the specialty necessarily, but if you're looking for that sort of thing, and your primary physician or ophthalmologist doesn't know, that would be the second place to look.
Is occupational something? I saw Julie's hand come up. Last question.
Yeah, just the same issue. Does with this disease, it's not like you're fully functioning one day and then blind the next. So it's like, do you declare disability on this day and then you have to stop working the very next day?
Yes.
Yes.
Is that
Once
higher?
you declare, yes, that's categorical.
Oh wow, that's interesting. How easy is it to have a fallback job position of an emergency room physician? Because that was going to be my fallback job once I went on disability.
I contradict you, but at our company, I actually filled out, I checked the box, I have a disability. Just
You can
to
certainly
have it on file.
Absolutely.
But I'm not saying I can't do the job, but I'm documented as.
Absolutely.
The day you call the insurance company.
Right. Employers like that because it shows
They
that they have
do.
diversity
It's
in their
diversity.
hiring.
And typically, when you apply for a position, that would be one of the checkboxes you'll have. Your demographic information, and but it's really up to you. No one can compel you to disclose it if you don't want
We
to.
also get a tax credit if they know you're disabled. I applied the Ticket to Work program. I did that. It's a waste of time. I would never do it again. It was the biggest joke going because by law, if I'm collecting Social Security disability, I'm working part-time and I'm allowed to make so much. If I go over the allotted what I'm making, then I could lose my benefits. Also, I got a question. I work security at night and day, and a lot of times I'll take the night shift because they call it lockdown, and they give me a vehicle to drive. I started in 2017, and I noticed on the new applications that are coming out now, they're asking, do you have a visual problem? You have to have depth perception and questions like that. Now my question is, isn't that against the HIPAA laws?
That is not, because it's an essential part of the essential function of your job. They want to make sure they're insuring you. They have disclosure requirements to insurance company, so that is something that they are obligated to ask.
In other words, they're covering that.
Okay.
So if you think about essential function, it doesn't mean the majority of your functions. It's what's required to do your job. So an airline pilot, the essential functions of a job for an airline pilot is to take off and to land. that takes
Because they don't,
a small portion of the whole trip.
they know I'm disabled, but they don't know I'm blind in one eye.
Right,
You know, so I mean, I never disclosed that. Like, no.
Well, that kind of gets back to that discussion we had yesterday in the convo, where if something happens,
Yeah.
you're the one that's screwed,
I'm in trouble.
you know?
Because you didn't disclose it, you mean, Corey? Because you just didn't disclose it?
I was
It's just like if
like
you're
I said, I
driving,
told
if you're
my-
driving a car, even if you have
I
a
was
valid
told them I was
driver's
disabled,
license.
but I didn't say, you know, I can't see.
Well, it's,
And I've been doing it since 2017, so.
Well, listen, guys, we need to,
Great session.
Yeah, thank you.